Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome everyone to our podcast today, which is part of a series run by the Holland Wilcox Health and Care Industry Group. In this series today, we're examining key issues that face aged care providers in respect of mergers and acquisitions and governance issues. My name's Carl Rosenbergs and I'm a partner at Holland Wilcox and co-head of the Health and Care Group at Holland Wilcox. Today I'm delighted to be joined by my colleague and fellow partner, Alison Choi Flanagan, an expert in health and care issues, and a partner from McGrath Nicol, Andrew Fressel. Andrew is a partner in corporate finance and transaction expert. He's recently done some transactions in the home care space, where he's involved in a sale, and he's done some transactions in both sides of the fence. He's done an acquisition in terms of home care as well, and the sale of some aged care facilities. So he's well placed to talk to us today about M&A and governance issues in the aged care space. So my first question is to Andrew, and the question's a broad one, but so Andrew, what should boards consider when thinking about merging with another approved provider from an operational, business and financial point of view?
Well, thanks, Carl. Yeah, it is a broad question to answer. And in aged care, there are a number of different considerations that you have to have compared to just traditional commercial transactions. Yeah, boards really need to consider the continuance of care of their ageing and often vulnerable residents or care recipients. And oftentimes, if a bank is merging with another bank, you don't have to worry about those sorts of things. I will try and address the question in two parts. So firstly, what are the broad overarching considerations? And then additionally, what are the common challenges that boards and key executives face? On the presumption there is a runway for a controlled assessment of a potential merger, the key things to consider before contemplating one, does the merger fit into or enhance either the business strategy or the ability of the organisation's mission? You know, we work with many not-for-profits and faith-based organisations, and it's often very important to ensure that there is a strong alignment in values as opposed to just commercial realities. The structure is really important. The aged care sector has many different players with non-traditional structures. So many of the faith-based organisations we've dealt with are letters of patent entities, for example, and they don't have a traditional corporate structure, which means that there is some complexity in actually affecting a transaction or a merger with another organisation. So that you need to get prepared. There's a lot of planning that's involved in transitioning in that instance. Making a really objective assessment about the pros and cons of a potential merger and identifying the top 1, 2 or 3 priorities that you need to navigate in terms of a merger. You know, I'd like to call them non-negotiables, but there's compromise in any merger. So you need to consider what are your key priorities in facilitating that merger. The fourth thing I touch on is your organisation's house in order? And what I mean by that is, are the financial records up to date? Are the legal agreements in good shape? Have you got employment agreements with all your employees? All those sorts of little things that sometimes don't get attended to all that well when you're busy running a business and those sorts of things. They really become extremely important when you are about to enter into a due diligence phase. So if you are exploring a merger, there will be a due diligence carried out on your organisation. And that's really where other parties or third parties will have a look to understand the values and risks of a potential transaction. And the due diligence process will be extensive, and they will look at every single agreement. They will look at all the commercial aspects. They'll look at the clinical governance of the way you're interacting with your residents or care recipients. And the final area I'd touch on is culture. And I talk about values and alignment at an organisational level. The culture of the people is going to be very important. Is your organisation accepting of change? there's a lot of stakeholders in one of these sorts of transactions, and the residents and the patients, the residents, the care recipients are obviously the focus initially, but you have employees. What sort of communication strategy do you need to devise to be able to get through the merger and sort of manage key steps and milestones along the way? It is natural that your employees might feel threatened by the prospect of a merger. In our experience, generally the frontline staff, which makes up the majority of the employees, will generally not have, will not be impacted because they're so important in providing the ultimate care to the residents and care recipients. But it will have an inevitable impact on the executive level and some of the back office functions. So I'd say overall assessment is capturing all of those things that I've just discussed, Carl. In terms of the common challenges that we're covering, which is something I think would be important to touch on, is make sure you understand what the impacts are on the residents and care recipients and communicate that with their family members and whoever else is involved. It's really, really important. And people can trip up very early on and get really negative sentiment if that's not managed carefully. Funding requirements. So you will need to navigate existing funding arrangements, financiers or people you have loans or bank facilities with. And the Department of Health and Ageing will need to be involved in that process. And ultimately, they will have a big say in whether or not you can transition some of these residents and care recipients to the merged entity. Be aware of the time and cost commitment involved in embarking on a merger. You're going to need professional advice, and you're going to need resources. Your team will have their day jobs to contend with, and addressing questions through a due diligence process will put a big burden upon your existing team members. So there may be the need for some temporary assistance in terms of resourcing. And finally, if you are embarking on a merger, I would make sure that you keep in mind the integration process. Facilitating the merger is only part of the challenge. Actually integrating the organisations once all the legal work has taken place to affect a transaction is really important, and also just to the general satisfaction of the ultimate care recipients, residents and employees. If you have a well laid out plan, you're in good shape, and making sure that there's a level of urgency about implementing that integration plan. So long answer to the question there, Carl, but
no,
it was a big question.
My initial thoughts on that answer, Andrew, is that there's an extensive checklist that needs to be thought through before you sort of proceed with a mergers and acquisitions transaction. And I'm glad you highlighted that this area is different in the sense that the continuation of care is something that everyone involved, and I'm talking the family members of people who are receiving care, would be concerned about. And so you've really got to have a pretty carefully thought out sort of PR campaign and really thinking through the messaging that goes out and the values of what's going to end up being a merged organisation. What's some of the surprises that might? I mean, I come from I'm an employment partner, so I come from that perspective, and I understand that, you said something about getting the house in order, but, you really want to make sure that there's no underpayment issues or things like that are lurking from a vendor's point of view, because that can affect the transaction going ahead, and also, I imagine, the price, like what you ultimately. Yeah,
I mean, you touch on an area that I have experience on, having been a surprise. So we've transacted on about 15 in-home care transactions, but in one particular sale process, there was an area of subjectivity in the interpretation of an award, and obviously the buyer had a different view to what our clients as the sellers had, and that was a bit of a surprise in the process because generally you get some objective advice and a lawyer sets you straight, but there were very strong opinions either way. The way we dealt with that was, we had an indemnity bridge to sort of navigate sort of the transitioning of the workforce from one arrangement to the other, and if that could be navigated in a sensible manner, then our client wouldn't, our client's indemnity wouldn't have been drawn. So it was a really practical solution that we had some good legal advice around to get to the ultimate result. But there are surprises, and oftentimes it's just you can prepare, and I think preparation is key. But there may be something that comes out of the woodwork, like a different interpretation of an award, or just perhaps your clinical governance isn't at the level that the merger party would like it to be. That even though it's adequate, or you've got there are just going to be surprises. I would say be prepared for surprises, but you can't plan for every single eventuality in a merger. You've got to do the best you can.
Yeah, preparation seems to be the key. I mean, given there's been such a lot of governance reform in the aged care sector, how do you see that impacting transactions in the industry? Will it lead to more, you think, activity and mergers because it's just becoming so difficult?
Yeah, I think you touch on some really good points there. So in terms of the difficult nature of it, I think we've seen a lot of consolidation over the last 2 years. We think it's accelerating, and we think over the next 12 to 24 months it's going to continue. So a key driver for me is that the sector lends itself to providers who benefit from scale and ability to leverage geographic density. So what I mean by geographic density is having a big workforce in a geographic region, and then if somebody calls in sick, you can navigate that with somebody else within your workforce. And it correlates with the increasing costs faced by the sector. So wages are going up, but other costs are also going up. So the benefits of scale mean that you generally have proportionally lower costs in terms of some of the overheads that you would generally have in a business and delivering services. The other key driver is just the ongoing increase in the compliance and regulatory obligations, which are required now as opposed to might have been required 5 years ago. Some organisations simply don't have the information systems, the infrastructure, or the scale to justify a big investment in improving those. And it's becoming harder and harder for those smaller groups to keep up with what the obligations are. And it's much easier for a large organisation to embark on a big investment. So, for example, if you had to implement a big information management system, an ERP system in an organisation, if you had a 100 facility organisation, that's a big organisation, the cost of that implementation proportionately to the revenue of the whole entire organisation is going to be much lower than if you had an operator who had 2 or 3 facilities. So, I'm not suggesting a complexity they're equal at a complexity level. However, the proportionate cost of that investment is much lower with a business that has scale. So we see that there are going to be mergers and tuck-ins, I would call them, of smaller providers who are starting to acknowledge that the most sustainable pathway forward and to ensure the continuance of care is to have a large provider effectively just take over the running of those facilities and operations. Given there are the changes in the industry and the broader macroeconomic factors around costs that I've flagged, there will be some form of financial stress that needs to be addressed, and that will trigger some activity. There will be mergers of similar and like-minded organisations who, and when I say similar and like-minded, I think in form of mission and size, that will see the benefits of being part of a larger organisation to ensure that they can provide a better and higher quality of care consistently to their residents' aged care recipients. And there'll still be the traditional acquisitions and mergers as the larger providers continue to seek scale and geographic density. We recently saw Opal acquire the Blue Cross Group. Obviously, Bain, have gone and undertaken a public-to-private transaction of the Estia business. So there will be just that general activity from the corporate world. There's an ageing demographic. There's obviously some innovation in the space, but we think scale and just that geographic density will be a key driver of consolidation. And that seems to be the way that just the sector is heading and probably some of the reforms are driving activity towards.
Yeah, I mean, I think that's right. I mean, I've learned a new terminology today, the geographic density, and I think that's a key part of this, because obviously the services are provided in an area, and with aged care you can't really move the facility, so it's stuck in a suburb, and you need to be able to bring the staff to the residents, and we all know that agency costs. So the more staff you've got that are accessible and you're not utilising agency, then you're able to provide your services at a cheaper rate. So there's a lot of benefits to scale, and you can see that could be a real reason why there's going to be consolidation in the area. I mean, from a governance perspective, Alison, there's a lot more for operators to be aware of, and are there more risks under the new aged care governance reforms that would cause people to think, well, okay, well, this is beyond us now, and that we need to look at, maybe selling?
Absolutely, Carl. So the federal government has released an exposure draft of the new aged care bill, and there are significant proposed changes in relation to corporate governance, including increased statutory duties and potential increased liability for directors and other responsible persons. So as a result of that, a number of the smaller providers are finding it difficult, first of all, to attract and retain directors because of the increased liability, but also, as Andrew said, to comply with the regulatory changes that are taking place. So definitely the way that the aged care reform is heading, there will definitely be more consolidation in the sector. We're finding, for example, we acted for a client that operates both hospitals and residential aged care, and I acted in that transaction. And they decided to sell the aged care and focus on their core business, because the amount of work of regulatory compliance was just not justifying the investment. So we'll see more of that. And also with rural and remote Australia, we've got community boards which don't necessarily have the skill set that's required to comply with the new Act when it comes into play. Currently, that's scheduled for 2025.
Yeah, so there's definitely, seems from every angle, there's reasons to expect that consolidation will continue, and that this is going to be a space where there's going to be a lot of activity because of all the reasons you both expressed. I mean, typically, what type of sales structures are available when you're looking at either selling or purchasing a business?
There's a various numbers of sales structures which are available, and it will very much depend upon whether the companies that are involved are for profit or not for profit. So, for example, for profit entities, they can sell shares or sell the assets and business. But for not-for-profit, obviously, companies limited by guarantee or incorporated associations don't have a share structure. And so there's ways that we deal with those mergers and acquisitions. For example, one company may become a sole member of the other company, or they may create another public company limited by guarantee, of which both entities enter into. So the sales structure depends upon the nature of the entities and also the risk appetite and the position of the parties. So, for example, if you're acting for a purchaser, it may be preferable to buy just the business and the assets and not take on the liabilities. So if you've got a target that has these hidden issues that are, quite large, for example, history of underpayments or regulatory problems or financial problems, there's a lot of debt or there's a lot of claims, then the purchaser may not want to take on those liabilities. Underpayments are still relevant for payments going forward, so it's still relevant, but certainly if you don't want to take on past liabilities, then the purchase of the asset and the business will help with that.
If I could just add to that.
Yeah, sure.
Alison makes a really valid point around trying to not, have any risk of those legacy liabilities within the organisation. However, you do need to be mindful that if you are transitioning assets in a home care type transaction, you actually have to transition each and every individual client across and have the department's approval to do so with a very detailed integration plan, as opposed to acquiring an entity that has a number of care recipients. So you do just need to weigh up the costs and benefits if you're on the buy side of being able to move quickly with some of the legacy items that Alison rightly mentioned.
True. So share sales, for example, is a lot faster transaction. Yeah, so there might be a reason to go ahead with it. So it's just a matter of weighing up the risks and the benefits of both options.
Yeah, I mean, from an employment perspective, I mean, with these kind of transactions, one of the key things is whether the vendor has enterprise agreements, and we've been involved in a lot of applications to Fair Work in terms of not having those enterprise agreements come across with transferring employees, so they don't have to run two payroll systems, eventually when they merge. So there's a heap of things to think about before entering into these types of transactions. Typically, Alison, what type of documentation is used?
Well, usually there's transaction documents, and that will very much depend upon the structure. For example, you've in private sector a share sale agreement or a business and asset sale agreement. There might be, for example, if the real property, the land is being sold, there'll be a land sale contract. For not-for-profit, there's likely to be an implementation plan, which works out the steps that are required.
So how should approved providers prepare for due diligence, which is, I mean, Andrew touched on it, and he indicated that you want to set aside some resources for sophisticated vendors or purchasers. I mean, it seems to me you probably want put a team together, because it's going to be pretty fast moving. So how do they prepare for due diligence?
I agree with Andrew. You need to put the resources into it, and also do due diligence yourself. If you're a vendor, do due diligence to see what your issues are, and as Andrew said, make sure your documentation is in place. Make sure your corporate documents are in order. Do work out whether you've got any employment issues. And also, one of the issues that we find is if you've got a larger business and you're selling part of it, you will probably have to demerge a part of that business off to sell it. And that could involve, for example, getting financiers or bank approval to do that. So there's a number of steps to take if you're a vendor to prepare for due diligence.
What's your purchases?
Obviously, if you're a purchaser, you undertake due diligence, so you'll do that as part of the buyer process.
Yeah, as part of that due diligence, what should purchasers look out for?
As we've already discussed, those problems within the vendor that you identify, and that will obviously affect, one, whether you want to continue with the purchase, and secondly, as to price. I agree with Andrew completely. It's really important to look at the culture of the target and to see whether that culture is aligned with your culture, and that you do financial due diligence as well to make sure that the business case stacks up as to whether that acquisition is going to add value to your business. Looking at employment law issues, for example, as I've said, underpayments. Looking also, we do a fair bit of work on encumbrances and securities to see whether there's an encumbrance over the assets or the business being purchased. Clinical governance is really important, as Andrew said, looking out for any regulatory issues. So there's quite a unique regulatory piece to mergers and acquisitions in aged care, including the transfer of the aged care places, looking out to see if they've had any investigations or unmets or sanctions. So that's really important. So there's a lot of issues for purchasers. Those already in the sector would be fairly familiar, but if you're new to the sector, just be aware that you need to apply to be an approved provider, so that you can take on whether it's the home care contracts or whether it's the aged care places. There's quite a unique regulatory piece for mergers and acquisitions in aged care.
Thanks, Alison. I mean, this is a question for both of you, but what tips do you have for boards and senior managers when conducting a merger?
It's going to sound repetitive, Carl, but I think it's preparation. So I think if you're on the buy side, effective due diligence, I always talk about is having some sound planning, the right team involved, and then having the right focus, right? So you got to try and dot the I's and cross the T's, but you're not going to get to the bottom of every minuscule issue. These organisations can be quite large, they're complex. So what you've got to do is have the right focus on the key aspects, right? So employment is a key area to focus on. The financials are a key area to focus on. Another thing to consider for boards and senior managers is to be disciplined. Potentially the merger isn't financially viable. It's not what you intended it to be, and therefore the assumptions that you made have been proven to be incorrect, and therefore you may need to walk away from that particular transaction. So I think you need to stay true to the ultimate goal, which you determined before you embarked on the merger. In any merger, either way, you've got to accept that there's another party involved and that there's going to be a need to compromise in various areas. So don't expect you're going to get your own way all the way through. And, we've touched on it a few times. Communications and a communication strategy is very important to manage stakeholders as much as possible. Obviously, our advice generally is to try and keep things confidential as possible, and hopefully there are no leaks. But in a situation where you're selling and you're marketing the business for sale, there might be 20 groups that come through a facility or two, and the senior management team get distracted. There could be some leaks and rumours. So you have to have a strategy to be able to mitigate the consequences of any leaks that may occur. And if you have a good strategy and you're ahead of the game, you should be well placed.
Thanks, Andrew. Alison, any tips?
I agree with Andrew, preparation in terms of getting your house in order. But another tip that I find is that give yourself at least a 12-month runway because it will take, to do the process properly, up to 12 months. And we find that some clients leave it to the last minute, and it causes all sorts of problems because, they're looking at, whether they're solvent or not. And so don't get to the point where, you're really worried about your director's duties in terms of solvency, and then you leave it too late and it's difficult to attract buyers at that point. So make sure that you give yourself enough time to go through the process is one thing. Also, to save costs and time, look at efficiencies in relation to the process. So, for example, as Andrew said, if you're selling a facility and there's going to be a number of bidders, then invest the time in doing a good information memorandum and getting the right consultants or advisors to help you with the process. And if you provide draft documents as part of the bid process and require people to respond to that, that's going to save you a hell of a lot of time in negotiations going forward. So the answer is preparation and also being aware of your timing rather than going blindly into the process.
Oh, well, thank you both for today. I hope our listeners have found the discussion informative. Watch this space. Thanks, everyone, for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website or the McGrath-Nicol website. If you enjoyed today's episode, then rate, review, or follow our podcast wherever you get your podcasts from.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.